4lawnotes.com presents Simpson v. Calivas, a case note summary. What happened? Simpson, the testator, executed a will drafted by Calivas, the attorney, the defendant. All real estate was given to testator's son, except a life estate in the homestead that was left to the son's stepmother and the testator's wife. Upon the testator's death, the son and his stepmom, filed a petition to determine if this homestead referred to the house and the surrounding acres or the house over 100 acres, buildings, and the family business on that land. The probate court admitted extrinsic evidence showing the close relationship between the testator and his wife, but did not admit notes taken by the defendant while talking to the testator that read house to wife as a life estate, remainder to son, the remaining land. The court construed the will as to the stepmom with a life estate in all of the real estate property. So what happened after that? 2 years later, the son bought out his stepmom's life estate for $400,000. Then he brought his malpractice action in contract based on a third-party beneficiary theory and negligence. The trial court directed a verdict and granted the attorney-defendant summary judgment and dismissed the son's appeal. So what's the issue here? First, does an attorney who drafts a will owe a duty to the intended beneficiary? And second, did the trial court err in ruling that the findings of the probate court on the testator's intent collaterally estopped the plaintiff's son from bringing this malpractice action? The holding and ruling was, yes, a drafting attorney owes a duty of care to an intended beneficiary due to the foreseeability of injury to the intended beneficiary. After the testator's death, failures in drafting a will deprives the intended beneficiaries of intended bequests. And yes, if a testator contracts with an attorney to draft a will and identifies people he wishes his estate to pass to, then the intended beneficiaries may enforce the contract as third-party beneficiaries. Second, the holding and ruling where the terms of the will are ambiguous, extrinsic evidence of the testator's intent may be admitted to the probate court if it does not contradict the express terms of the will. And while both the probate court and the superior court are competent to consider the same evidence on the issue of testator's intent, it is not dispositive of an identity of issues. So that is, the probate court's role is to determine the testator's intent expressed in the will. Direct declarations of the testator's intent are generally inadmissible in probate proceedings. The findings of actual intent is not necessary or essential for that judgment, so even an explicit finding of actual intent by the probate court cannot be the basis of collateral estoppel. Collateral estoppel is only applicable when the proceedings is essential to the judgment of that court. So that was 4lawnotes.com presenting Simpson v. Calivas, a case note summary, more available at 4lawnotes.com.